He's on his motorcycle with his iPad, did you say?
Yeah, but he doesn't have a helmet
Good.
on.
I
So,
believe we're live now. Is
yeah,
the red
that's
button-
fine. I just wanted to
Yep.
point out that Senator Benning's helmet was missing.
Good thing we're live and not dead.
You're getting a sunburn.
Before we actually have a walkthrough of the bill, there is a bill that many of you may have heard of that passed the House, H568. I did not put it on our priority list, but one of the witnesses tomorrow may talk a little bit about that bill. And that's the bill having to do with human trafficking. And we had a bill in our committee, and we did take some testimony before we left. And I didn't put it on a priority list because of the controversy surrounding the sex worker study committee that the House put in the bill. But we'll see what happens and how much time we have between now and adjournment, whether the committee wants to take up that bill. But you may hear testimony about that bill as we talk about this bill, which is dealing with the sexual exploitation of children. Part of the reason for bringing it up today and hopefully passing it quickly is that during the pandemic, unfortunately, there's been an increase in the viewing of pornography, particularly the children. And some of the witnesses will be talking about that increase and this bill. So Michelle, if you could walk us through the bill, unless there's any questions from the committee.
Sure. So good morning, everyone. So I'm gonna just talk a little bit about the bill as a whole, and then I'm gonna ask Peggy to put up a copy of the House passed version and have her move through it. I can't believe that we're 2 months in and this is actually the first walkthrough I'm doing, but we've been dealing with all the COVID stuff and everything else. So I haven't learned the trick of how to put it up and scroll through, but I will for the next meeting. So
Alice, go ahead.
Now, can we look at it on another device?
Yeah.
sure.
It's H936.
It's
What
on the
is it?
website.
Say it again.
H936.
Yeah, it's posted.
Oh, okay, thank you.
And that's
Okay.
actually what I do. I have you guys on my
Yeah.
iPad and then I have my
Yeah.
laptop in front of me where I view the documents. It works better for me, but
Me too.
I think
so
I'm sorry.
I'm sorry.
I said, I think
So-
they prefer to do it that way, but I'm happy to do the screen too, whatever works for you
Well, it
guys.
doesn't matter to
No.
me. I don't
Does the
need
committee
the screen.
want the screen or do you have
No.
copies?
We have
No.
copies.
Okay.
Okay,
so-
great. That works
don't
better
need the
actually for
screen.
me. That's
Okay.
great. So
Great.
this is I just wanted to start out talking about, so, lots of times, or most of the times people will come to Ledge Council with an idea and we do all of the drafting. This is one of those bills that primarily came from the Attorney General's office as a request and was a committee bill in House Judiciary. And so I'm going to take you through and give you an overview, but I'm guessing that probably a lot of questions you may have about, well, what kind of conduct would this look like, or very specific kind of factual things, I would say, or I just wanted to give you a heads up, are probably better for the witnesses from the Attorney General's office or from law enforcement or from Marshall to kind of get into the practice areas about how they would apply, but I'll do my best here. So we're amending the chapter. It's chapter 64 in Title 13 on sexual exploitation of children. And so generally what this chapter does is it addresses issues related to what we commonly think of as child pornography. There's one crime that's in that chapter that's not related to that, and that's luring a child. But other than that, it has to do with sexual performance involving a child. And so one of the changes that may seem small, but is pretty substantive and important to folks is a name change. So switching from, you'll see there's a crime of possession of child pornography, and that's changed to possession of child sexual abuse material. And so this is something that's the name change is happening across states, looking and saying, well, when we think of pornography, typically we're thinking of something where you have consent and people are agreeing to engage in a sexual performance. And obviously, when we're talking about children, we're talking about abuse, we're talking exploitation. Children cannot consent to a sexual performance. And so there's the name change there. And I am working on switching it over for myself and make sure that I refer to it appropriately. I'm just going to talk a little bit about the few changes in here because they're throughout the chapter. There's a few changes in the definition section, and then there are a couple changes with regard to how you share material, sexual abuse material, and then a change with regard to possession or knowingly accessing with intent to view. So I'll start on page 1 and on section 1 in the definition section. So this would apply to everything throughout the chapter. And the first change is if you look at subdivision 2821, subdivision 2 on the definition of sexual conduct, and you'll see that you have a number of things under the definition of sexual conduct. And the new change is the addition of the subdivision G, which is any simulation of any of the above described conduct. And so again, I think I would prefer to have the witnesses talk to you a little bit about why they feel as though that's important to add that. I will note that that's still talking about conduct that is involving an actual child, not talking about, let's say, animated or computer generated simulation. But an example might be that if you look at subdivision 2A and it talks about conduct between certain body parts, is that maybe there isn't an actual touching involved. So like what you would have with an L&L with a child, which involves the touching, but you could have a simulation of that involving a child, and then that would qualify under the simulation.
Just
Yep.
quickly,
Bill?
Michelle,
Mhm.
just want to make sure I understand what you're saying. So simulation seems like a very broad term, but as I understand what you're saying 2A controls that it would have to be a simulation that is directed at a specific physical child. In other words,
Yes, involving the child. Yes.
right. So you couldn't have just someone who had, say, created an animation free of any real physical person fall under this.
Right.
Okay, great.
Yep.
Thank you.
Is
Yep,
there
and
any
I'm sorry.
question, and I must have taken myself out of the video. Is there any real change in the age of 16 years of age? Crossing the age of 16 years and having 16 years, is that just stylistic?
That's just stylistic, and that's just
It doesn't
so-
change the age at
No,
all?
it doesn't change that at all. So you did note something important there, which is that for purposes under this chapter, child's means under the age of 16, and that's because that's what you have as the age of consent in Vermont. And so that isn't changed, but there's we're constantly revising the rules for drafting, and this
All right.
chapter's been around a while. So there are a few little small technical changes, but it doesn't change the age. The next change is if you look at subdivision 4 for sexual performance, and you'll see that the current language says that means any performance or any part of a performance, which includes sexual conduct by a child. And so this expands that so that it would include sexual conduct by, with, or on a child. So broadening that. So it might be that the child is not necessarily engaged in the sexual conduct, but there's someone else engaging with the child or on the child.
Okay.
And then the next change is on page 3 on subdivision 5 under the definition for promote, and you'll see on line 3 included in there the addition of make available, and then on line 4 it would also include file sharing or peer-to-peer networks.
I remember, this is so long ago, that Bill Sorrell was Attorney General explaining peer-to-peer networks. Should I wait for somebody from the AG's office? Because
Yes.
I've forgotten the peer-to-peer network, exactly what that involves. So,
Yes, me too. I'm embarrassed to say how many times I have to go to my middle schoolers to ask them about some of the
yeah,
technology.
so
stuff.
I've kind of forgotten the testimony. I remember Bill Sorrell trying to explain it, and he was fumbling a bit. So maybe we'll wait for David Shearer or Matt Raymond.
Right. I think that would be ideal.
Okay.
So in terms of moving on there, like I said, there's a few technical changes. I'm just going to move on to the next substantive change. And that would be on page 4 in section 2824, which is promoting a recording of sexual conduct. And you'll see in subsection A, that is where you're bringing the language in that we already talked about. That was in the definition section for sexual performance. And you'll see it's no person may, with knowledge of the character and content, promote any photograph, film, or visual recording of sexual conduct by, with, or on a child. So again, kind of you'll see that a few times through the bill.
Where's this?
This is on page 4, section 2824 in subsection A.
Okay, subsection A. It's a.
Mhm.
I don't have
So it's
that
just
in-
that one policy decision about expanding it
Actually-
from conduct by a child to be also inclusive of with or on, and that's done.
Oh,
at this
okay.
time.
Yep. Actually, it's
So-
on my version that I just printed out. It's on page 3. That's why I couldn't find it.
Oh, sorry
Right,
about that.
we don't have lines, Michelle.
You
we're
oh,
looking
you have a
at the-
different version.
We're looking at as
Yeah.
passed by the House, and there's
Yeah.
no line numbers, and the
Right.
pages are different.
Okay, sorry about that. I'll just refer to the section number then.
Yeah, please.
I'm going to skip over 2825 on the penalties because it relates to something after that, and I'll go back to the penalties. It's kind of just kind of plunked there in the middle. If you look next to section 2827, which is possession of child sexual abuse material. So again, this is where I talked about the name change. So we're
Yep.
moving from referring to child pornography to child sexual abuse material. And you'll see in subsection A are the elements of the crime. So no person shall, with knowledge of the character, content possess or knowingly access with intent to view.
Michelle,
Yes.
if I could just ask, so is this getting at a technological distinction between downloading something and viewing it?
Yes.
And then the question would be, the evidence that someone viewed something would be that they clicked on it. How would intent be proven in that case? So what you have as evidence is that someone has clicked on a picture on the internet. How would it be, how would you demonstrate that when they clicked, they knew the person was underage?
I think I would refer that to the practitioners, and you could to talk to you about that. I mean, you have the
Okay.
knowingly mens rea there, so
Yep,
that is intended to avoid, accidental. You're scrolling through things and something pops up, and you're like, get it off.
I mean, I could think of a number of corroborating pieces of evidence that you could offer. I'm just wondering, we live in a very clickable world.
Sure.
I'm just wondering maybe from the point of view of the Attorney General's office, what they would view as the threshold for when you would prosecute something like that.
Right.
I'll save
think-
that question.
Yes. Thanks.
Okay.
You also see in subsection A is the addition of the language with or on a child there as well. And then I'm going to go back to the penalty section in section 2825. In subsection C, and those are the penalties for possession of child sexual abuse material, and the penalty for that, and that is just bringing through the language that we just talked about, which is accessing with intent to view. So if there's a violation, it's just truing it up there. And so that's it. Those are the only changes. Like I said, there's a few technical there, but if I didn't mention it, it's just a little bit of cleanup language.
May I-
And all of these are offenses that are required for a person who's convicted to be registered on the sex offender registry.
I want to consider making it effective on passage. I know we're close to the 1st of July, but my understanding is during the pandemic period, it's been an increase. So if people would like to speak to that as well. I know we're not that far from July 1, but it may seem more like we're at July 1 today than a normal May temperatures. But so with that, I guess we'd go to Marshal Paul. And, or should we go directly to the Attorney General who brought the case?
I think it might help to have the Attorney
Even though
General's office
Marshall was
talk.
scheduled, I hope he doesn't take offense if we go to David Scher or Matt Raymond first.
That's fine with me if they go first.
Okay. David or Matt?
I would kick it over to Matt if he's ready to go. I think he'll be the
Okay.
most informative for the committee to hear from, and I can come in after if there's any technical questions that have come
All right,
up.
thank you.
So can everybody hear me?
Yep.
Yeah, so these changes, although small, will make a big
Matt, could you
difference.
identify yourself for the
Yep,
record
I'm-
and your position as well? So that,
Sorry, Matt Raymond. I'm the current commander of the Vermont Internet Crimes Against Children Task Force. I'm a
with the Vermont
detective
State
out of
Police.
out of the Office of Attorney General.
Oh, okay.
So the just a little background on the ICAC, just to make sure we're all on the same page. The Internet Crimes Against Children Task Forces first came around in 1998 as a response from the Office of Juvenile Justice and Delinquency Prevention out of the DOJ, realized that local and state law enforcement were woefully under-equipped and underfunded to fight child exploitation on the internet. So they came up with 10 starting ICACs across the country, and we were part of one of the first ones, which was tri-state, Vermont, Maine, and New Hampshire all came together for the Northeastern ICAC. And then in 2008, Vermont broke out on its own, and Burlington PD was the lead agency and ran it for the state. In end of 2011, beginning of 2012, it was actually the first full-time ICAC investigators. Before that, it was always an ancillary duty to your regular duties if you were on the ICAC. So you'd be on a police department as a detective somewhere, and then on top of that, have ICAC cases assigned to you. So then the Attorney General's office, through the legislature, got permission for a full-time investigator, and then added a second one shortly thereafter. And those were the first time that there were full-time people in Vermont doing this. And in 2015, the ICAC was transitioned to the Attorney General's office to run it, and that's when I became the commander. Since that time, the cases that we get, which are either, we used to do proactive cases, which we've pretty much shut down just because we are just overwhelmed with reactive cases, which come from mainly cyber tips, and I can explain that. But they come from cyber tips, other police departments, the public. We get a lot from DCF, parents, teachers. But the cyber tips come in, any electronic service provider, which would be Facebook, Google, any of them, that has, that offers any type of electronic service. If they uncover child exploitation on their platform, they're required to report it to NCMEC, the National Center for Missing and Exploited Children. At that point, NCMEC then decides which of the 61 ICACs across the country. There's 61 because some states have multiple. Vermont, we just have one ICAC run that covers the whole state, but you can imagine California has 5 because of size and population. So there's 61. When they figure out which ICAC it should go to, they assign the cyber tip out. When we first took over in 2015, to 2020, that number had gone up more than 2 times. So we're getting like, I think it went up 219%, the number of cyber tips we got. And then, so that took 5 years to double. And then during the stay home, stay safe, it doubled again, but that was just in 2 months. So the number of cyber tips we're getting is just astronomical. So anyways, in investigating those, we come across issues that don't fit under the current law, and that's why we ask for some of these changes. And I can explain exactly why we ask for these changes. And I just warn you, it's a little shocking, but this is what we deal with. The simulation, we get a lot of images where you have a clothed child that is young, very young. Most of the stuff we deal with, I would say the kids are under 8 years old easily. And nowadays we're just getting a real onslaught of infant and toddler child sexual abuse material, which is really disturbing. But you'll have a child with an open mouth, with a male about to insert his penis. And under the current law, that's not child pornography. It's absolutely a reprehensible image, but we wouldn't be able to charge that under the current scenario. That's what the simulation is meant. And there's other scenarios, but I don't really want to beat everybody over the head with that offensive type of thoughts. But that's what it's meant to enforce. And the knowingly access with intent to view is, when this law was written, technology wasn't what it is today. Streaming, wasn't even a thought at that time. And now we have basically live streaming acts where people will set up just like this on Zoom, but they'll have vetted the people they're going to put on by making them require them to provide them some child pornography, and then allow them into their Zoom meeting, and then they'll actually assault children on demand, where people will be in a meeting like this. One of them will actually have a child, will be sexually assaulting that child, where the other people are telling them what to do. And that would obviously be knowingly accessing child pornography. And that's what this is meant to do. Currently, under the current setup of the law in Vermont, if say everybody on it was from Vermont, we would be able to charge the person sexually abusing the child. But if no one actually downloaded it, under the current law, they haven't possessed child pornography, which doesn't make common sense.
Matt,
Yep.
quick question. So I see what you mean by that, and clearly that's in and of itself proof of intention, because there's
Right.
a whole process the person had to go through. Am
Right.
I right in assuming, and maybe this also goes for David Scher, but am I right in assuming that a click of a single click of something would be difficult to prove under this, because there wouldn't be that substantiating evidence of intent to view?
Yeah, we wouldn't be able to arrest that person because there would be no probable cause to show they knowingly accessed it. But you have to realize nothing happens in a vacuum. When we go and look at someone's computer, we're looking at search terms. There's a lot of stuff saved on your computer that the average user doesn't see. But when we put forensic tools across it, we can see what they've been looking for across the internet, and that goes a lot into it. The other part would be we get cyber tips where someone had uploaded a file into their Google Drive, but they'd uploaded at the time when we look into it. We just get told about the one file of child pornography or child sexual abuse material. But then we follow up with an online content warrant to Google to see what else was in there, obviously for user attribution, and obviously to see if there's any other child sexual abuse material. And we go and interview the person, search their devices with search warrants. And sometimes we found that somebody did a mass download of adult pornography and mistakenly got a file of child pornography. And in those cases, we obviously don't charge that person because we're not out to manufacture sex offenders. that does happen. And especially in the internet today, people can inadvertently and accidentally come across child pornography, which is why there's the knowingly in there to prevent someone from being able to charge someone who accidentally did. But I can tell you from doing this full time since, 2011, 2012 era, it's very obvious when you're looking at someone's computer that's doing it knowingly and when someone that did it inadvertently.
And back to your first example, you would have text messages or emails between the parties, kind of
Right.
laying out what's going on. So thank you, that's
Correct.
helpful.
So,
And now the
just
rest of the
about your,
changes. Sorry.
Matt, going back to the Zoom platform type meeting,
Right.
people could be in Vermont, people could be in New Hampshire, Colorado, Puerto Rico, all viewing this. But would Vermont be the only state where they might be able to be charged?
Well, I
And
mean,
would you be able to charge somebody from Puerto Rico if the actor, the person who's doing the actual sexual acts on the child is from Colorado, let's say, and people in Vermont are watching it and the other states, would you be able to charge all of them or just the Vermont?
so we work in concert with all 61 ICACs. In fact, the ICAC commanders from all 61 meet quarterly. We have an online platform where we can share cases back and forth, because many times we will have either the victim in Vermont and the offender in another state, or vice versa. And in that case, we work the cases jointly, and then we make joint charging decisions. We always have the option, of course, much of all of this is a federal crime as well.
Right, well, that's.
So
what I
we
was
have the option to
wondering.
charge federally. We have the option to charge in the home state or in our state. But if any of the conduct occurred in Vermont, we're actually able to charge in Vermont, but we much rather charge where the person is in their jurisdiction. It's a lot less complicated.
Okay. Senator White has a question.
This isn't a question, but I feel like I'm about to puke. And I cannot believe, Matt, that you've been doing this for 8 years and have kept your sanity. I'm,
I get that a lot, and I can tell you, so I received a call from the chief of the criminal division way back, Cindy McGuire, who asked me to come over and start doing this stuff. And I thought the same thing, but I will tell you, one of the first cyber tips we did was a cyber tip from Photo Bucket. And it was a 30-something-year-old male sexually assaulting an 8-year-old repeatedly at night, and had uploaded the videos to Photo Bucket. Unfortunately, it was a very small ISP in St. Albans who didn't log the users of their IP addresses. So when we went to try to figure out who this was, it's usually, we get the IPs from Photo Bucket, we get a subpoena to, say, Comcast or Fairpoint, and they provide us the subscriber of where this entered the internet from, and then we track it from there. In this case, they were like, we know what's our IP addresses, but we can't say, who the person, the end user was. So we ended up doing a series of emergency online content search warrants based off stuff we found in the Photo Buckets, and it took probably a week and a half, almost 2 weeks, where this stuff is still populating in Photo Bucket. And we finally figure out it's this residence, and we're up there knocking on the door at 6 in the morning. And the child had been wearing these very distinctive pink and purple with peace signs on them, fleece pajamas on videos. And we're knocking on the door, and no one answered. And I sent my then partner back to the car to try to get a house phone, a call to the residents to wake people up. And next thing you know, skipping as he's walking down, skipping around the corner, was this girl that we'd been seeing sexually abused and hadn't called out for help. And we're able to remove her from the situation and arrest the abuser, which was a guy that we found that had serial dated women with kids that age, had drugged the moms at night and sexually abused their daughters. And none of them had reported him because of his behavior. And he had convinced them that they couldn't. And right there, that's what keeps me sane, because I can tell you that story more than 24 times across Vermont, where we've saved kids from sexual abuse because of these type of tips, where they wouldn't have otherwise been abused. And this guy would have gone on and abused more and more girls. So that's why these are important.
Thank you,
The,
Matt.
the sad part is right
I
now
realize,
we're so
I
far
realize
behind
you're important,
because
but
so the other thing I do for Sanity is we have mental health is part of our part of our budget each year, quite a large part. And there's mandatory meetings with wellness personnel. So and all of our staff go through that.
Could not to, that's information regarding the St. Albans case is really interesting and helpful to understanding how you can deal with this, recognizing there is some success, and that you do save kids from further abuse. Getting back to something a little more technical, what is a peer-to-peer network? And that is that, and I'm not sure what that means.
So in general, a
I
peer-to-peer.
mean, is
just
that
means-
like this meeting right here is a peer-to-peer meeting on Zoom?
Well, peer-to-peer is basically when you're making a direct connection. This is not, we're going through Zoom's centralized server right now. So this isn't actually peer-to-peer. What peer-to-peer is when you're making a direct connection between your computer and somebody else's home or personal computer. The difference between peer-to-peer is you're not going through a centralized server somewhere. You're contacting directly. So if I have files on my computer, you can get on the same network and using the same protocols, you can share files with each other. There's the BitTorrent network, eDonkey network, Nutella 1, Nutella 2. There's a bunch of different ones. And they're obviously were not designed for child pornography. They were designed for a way for people to easily and quickly share files with each other. People use them routinely for music and movies and, not nefarious stuff. But unfortunately, when people can use technology for their needs and with, someone that has sexualized interest in children and want to share it with somebody else and try to do it anonymously, there's been quite a lot of traffic on peer-to-peer networks over the last decade on that. And this is just addressing to the sharing over peer-to-peer networks. So basically, if I have files on my computer and I get on this network and I put these files in my shared folder, then I'm allowing other people across the world to access those files. And then it becomes increasingly difficult to remove those files from the internet because, you're just chasing them all over because they're on everybody's personal computer.
Okay, so it's that electronic transmission, file sharing, peer-to-peer networks. Okay.
Right.
So it includes all
So
of
basically
those.
you can get online. Say it's BitTorrent is one of them. You get online. There's a lot of different BitTorrent clients. It's just BitTorrent software that you can download for free. When you download it, it cautions you not to share child pornography because it's illegal. And that when you're downloading something, other people are downloading from you, can be downloading from you the same file. So you get on and then you have to search for the files that you want, enter the torrents into your software. So it takes active steps. No one can send in a peer-to-peer technology situation. You can't unknowingly send images to somebody else. It takes active steps to download.
During
this
this
material.
pandemic, are you seeing an increase in cases or?
We're seeing an increase in our cyber tip cases. Like I said, they've gone up. It went from 2015 to 2020, they doubled. And then just in the first 2 months of the shut-in, we doubled again that fast. Which is just impossible to keep up with at this point.
If we currently, if it's a peer-to-peer network, you wouldn't be able to charge someone.
No, we can. And under the current law, I have to look at it again. In the current law, we could too, but we were just making it clear that peer-to-peer networks were part of this because.
Well, what I remember of Bill Sorrell's testimony, and that's how long ago, was that they were thumb drives in the peer-to-peer network that people shared evidently.
Yeah, no, so it's just electronic files in the peer-to-peer network, and you save them wherever you designate on your computer. So you can say, share my photos folder, or you can say, just share this private photo, you know,
So
this.
if I
whatever you
were to
named
give
them.
you this thumb drive, that's a peer-to-peer also though, right? If I was to mail
No,
this to you.
no,
or
no, this is just electronic peer-to-peer networks. So that's not
Okay.
the same.
not
So
the-
this is online networks.
Whoop, I got a dog's excited.
So currently promote means to procure, issue, manufacture, publish, sell, give, provide, lend. So provide, when I'm putting these files onto my computer and providing them for anybody else that wants to download them from me, it would already be under promote. And in fact, we've charged people with that. But this just makes it very clear that when we say make available and we're including file sharing and peer-to-peer networks, that's what we mean. And it's a warning to stay out, don't do this, you know, on these networks, because it's kind of prolific
Alice,
on
can
them.
you
And
take
we
over
were
for a
doing,
minute? I have to help the dog.
sorry.
Keep going.
Oh, okay. So this is just to make it clear that we are including those in the sharing. I could speak more intelligently about it in the current situation if we were actually monitoring it right now, but we're so inundated with cyber tips that we've shut down any of our monitoring or proactive sides of our ICAC. We just don't have the personnel.
I see.
So normally, in the past, we were on these, we have computers set up to run on them to monitor people in Vermont doing it and then catch the people that are doing it. But we just don't have the personnel right now.
If I might ask, how many persons do you have working in your unit?
We have 2 full-time and everybody else, it's on top of their regular duties.
I see.
So I know that this isn't the committee to talk about this, but we'd had a request for, we have 2 positions and we converted 2 different positions within the Attorney General's office over to ICAC positions. And we'd asked for funding. This is of course before COVID hit and funding went all wonky in Vermont. And now, so we were already at wit's end and needed people. And then this just tipped us over the top. And so I'm hoping, fingers crossed, and praying that somehow we can make it through and still fill those positions. Like I said, we have the positions, we just don't have the funding.
I see.
Thank you. I'm sorry about the disturbance.
No problem. And the only other changes that I didn't talk about were one that's throughout it is with or on a child. And very disturbing, we have adult males ejaculating on infants and videoing it. And that doesn't fit the current bill either, because that's why we want to add with, on, or by a child. And then, changing child pornography to child sexual abuse material, I think is very important. And it asks for that change. When people think child pornography, they think, either baby in the bathtub or age difficult material where, they're just barely not of age. And that's not what we're prosecuting at all. Like I say, almost all of our cases are under 8 years old, and a large majority of them are infants and toddlers. And it's not child pornography. It is, basically crime scene footage of the sexual assault of a child. So that's why we'd like to change it to child sexual abuse material.
Matt, thank you. Questions for Matt?
So I just have one question. So the last piece,
Alice?
the last piece that you spoke about, that you said you wanted to add that to the bill, has that been added to the bill?
Yes, that is in there. The child sexual abuse material was changing the terminology from child pornography to child sexual abuse material. It's already in there.
So
It's at the top, that's the top of 2827 in the heading. It's read possession of child pornography. Now it's possession of child sexual abuse material.
yes, I understand that. I was talking about, you said you wanted, Matt, I thought you just said you wanted to add the piece about someone ejaculating on.
Oh,
Is
no,
that,
that's already in there. That's throughout it. It says it says by, it used to just say by a child. So it meant the child had to be doing something sexual. And in many cases, they're doing something to a child. It's not by the child. So
Right.
that's why we wanted to change it from by to with or on a child, which would capture, this reprehensible behavior.
okay, thank you.
Other questions for Matt? Matt, thank you very much for your testimony.
Thank
Very
you.
helpful.
Thank you.
David, did you have any comments at this point?
No, I really don't have much to add. David Chair with the Attorney General's Office. Matt is the expert on these issues, and I'm happy to answer any questions if there are any, or stay on the line if one's come
I
up
hope
later.
you'll
But
stay on the line. We're going to turn to Marshal Paul from the Defender General's Office.
Sure, thank you very much. This is Marshal Paul from the Office of the Defender General. We have a few concerns with the bill. They are all sort of in the vein of clarifying things that I think the bill leaves unclear. So to begin with, I would start with in the very first section in 2821, the definitions. It adds in subsection G, any simulation of the above described conduct. The way that that has been described to the committee, I think is completely legit. That if there is simulated conduct taking place that affects a real child, that can be criminalized. But there was a case in 2001, 2002, somewhere in there, somewhere right around the 2000 mark, just after, called Ashcroft v. Free Speech Coalition, that considered the question of simulated child pornography, meaning that the child used in the pornography was not itself a real child. And the Supreme Court held that that could not be criminalized constitutionally, that was protected under the First Amendment. My concern is that in G, where it simply says any simulation of the above described conduct, that could be read to include not just what it's intended to include, which is simulated conduct involving a real child, but it could also be read to include actually simulated child pornography. And the problem with that, I mean, in other situations, it may be appropriate to just let the courts figure that out on their own. But in a First Amendment context, there's a doctrine in the First Amendment called facial invalidity, where if some part of a statute is over-inclusive, the presumption is that the entire statute needs to be thrown out. And that's a special rule that applies to the First Amendment and to a few other situations that involve fundamental constitutional rights. But what it means is that whenever you're tinkering with a statute that sort of intersects with the First Amendment, if you do something that is unconstitutional in one part of the statute, you risk the entire statute being declared facially invalid. So I would suggest that something be done to make subsection G more clear, that it's not trying to criminalize simulated children, but it is trying to criminalize simulated acts upon real children. So that's my first concern. And the second concern, which I think has sort of been touched on, and this was really, I think, the last concern that I have, is around the use of the term peer-to-peer networks. File sharing is something that if you look in a dictionary, you can find a definition of file sharing. And that's usually, when it comes to technical terms, if it's something that you can find in the dictionary pretty easily, then I think that's good enough. But peer-to-peer network is, I looked through 3 or 4 dictionaries. I couldn't find a dictionary. I'm not saying there's no dictionary that has peer-to-peer network in it, but I couldn't find one. And what I would hate to have is a bunch of jurors and judges and attorneys who don't actually understand quite what they're talking about, trying to determine what a peer-to-peer network is. So my suggestion would be that peer-to-peer network should be defined in the definition section so that we don't wind up with jury trials going on where somebody, a judge, who may not actually really understand what a peer-to-peer network is making decisions and instructing a jury about what a peer-to-peer network is. So I would suggest that peer-to-peer network should be defined in the definition section. Other than that, we don't see any particular flaws with the bill.
Thank you. It's helpful. David, any comment on those two?
Sure,
Matt?
I'll start with the second one first. Certainly wouldn't have any objection to including a definition of peer-to-peer network. I agree that that could be helpful. With respect to and I think we could work on providing that and perhaps working with the Defender General to make sure we have one that's clear and acceptable. With respect to the first issue on the simulation, I have reviewed the Ashcroft case that Deputy Defender General Paul referenced. I think that our statute is quite different than the Ashcroft case because our statute by definition requires an actual child to be involved in the activity that you're talking about. And that, is when you look at section 1, the definition section, which defines a child, and then you go to subsection 4 of that section, which makes it clear that we're talking about sexual performance requires a child to be present. This means that there must be an actual child present. The issue with in order for there to be a criminal act, the issue with the Ashcroft case was that the definition was incredibly broad and pretty explicitly included pure simulations like animations or electronic animations or something of the sort. And the Supreme Court did say that something like that is overbroad. And it could have criminalized things like the suggestion of inappropriate material. This one, though, is, I think, by definition, the statute already in current law requires a child to be present. And I think that overcomes any issue with the simulation and is not analogous to that US Supreme Court case. So I don't share that concern. That being said, if the committee is worried about it, I think we could put some sort of a disclaimer clause at the end of that saying that the simulation requires a child to be present, a child as defined in, well, you wouldn't have to say that, but just a child to be present in order to cover that. But I do think that the way the statute's already written, it requires a child to be present, and we don't need to re-clarify that.
Okay.
Senator Sears,
Well-
can I add something there? Is that okay?
Yeah, we're almost into markup here, and I'd plan to do that tomorrow, but sure, go ahead.
I was just going to note for the committee, so because I had discussed that with David earlier, and I think I get Marshall's point that if you look at it in the definition section, it seems a little vague, but then when you look at the elements of the crime where it requires that it be sexual conduct by, with, or on a child, it gets to that's where you loop in and it requires an actual child, but we can add a little something there for clarification. And I think if Marshall has some suggestions, I'm open.
Yeah. Dependent upon Senator Bruce's question, I think it would be a good idea for the committee tomorrow to have like an amendment that would deal with simulation as well as peer-to-peer network definition. Seems like those are good suggestions, but Senator Baruth had a question.
Not
Or
so much a
comment,
question.
I don't know.
Yeah, a comment. I come at the word simulation from a different angle, which is I teach postmodern American literature. Simulation is an extremely widely discussed postmodern concept that draws in every kind of creative enterprise. So I'm convinced by what David has to say and what Michelle has to say. I think looking at it again more specifically, I do think that word is controlled and placed within the parameters of a real child. Even with that said, if we can do something with the word simulation, I think, all to the good.
Well, I agree. Sometimes I see things on TV, particularly in ads, for example, where it's hard to tell the difference between, was this a real person or was it a simulated person?
Right.
They're, you know, so. I think what I think, Michelle, if those two things, and David and Marshall, if you have suggestions for how that would look, that would be fine. What we're gonna do is take a 5-minute break, come back at 11 and hear from Pepper, Sarah Robinson, and anyone else who wants to comment and any other questions.
Nick, while you take a break, I'm going to ask Michelle, Matt, and Marshall to just stick on for a minute and David, because I have a suggestion on how you may want to tweak that.
Okay, that's fine.
Just
All
be
right.
aware that you're on YouTube, Senator Benning.
That's okay. That's fine.
Okay, just want to make sure you knew.
Thank
I'm
you.
just looking at that language, trying to clean it up and suggesting this as something you might want to chew on, that any simulated act involving a child of any of the above described conduct would probably cure, at least as I'm looking at it, and I can repeat that, any simulated act involving a child of any of the above described conduct seems to take care of Marshall's concern. That's just a suggestion I'll throw out there and let you guys chew on it. Other than that, I'm taking a break. See you later.
Okay, thanks, Joe.
Well, that was a cheery morning. Hi, Alice.
So Peggy has my video turned off.
So how about this? I have a woodchuck in my basement,
In your basement?
uninvited.
How much wood did he chop?
He can chop a hole right through right through the wood where
I have a rat in my basement, uninvited.
this guy is in there right now. And I need to get, in order to go down there, you have to go through a small trap door and take the trap with you.
Well,
Nobody else is home to help me, but he's chewing away. He's chewing at the, and woodchucks can chuck wood.
Oh my
He's had
goodness, your
enough.
woodchucks are at it again, Alice?
One is in my basement right this minute, in the part that's the crawl space where the furnace is. It's awful. I can hear him chewing.
He's like, I've had enough of this infestation of Nitkas.
Yeah, and I'm gonna
Right.
get out by another
can
hole.
you hear that truck back there? Is that bothersome?
No,
No.
I had to get out of that room.
I don't blame you.
I'd like to get out of this.
Alice, my mom, before she died and had to move out of her place, she lived right next to a stream. And the beavers kept trying to flood them out. And
Oh,
so she,
really?
yeah, she was a very, loving person toward animals, but it got to the point where it was her or them.
Oh
So
my
she
God.
had a guy come in and trap this beaver, and he pulled out a 90-pound beaver.
My God.
It was like as big as a pony.
9.
So she had this picture on her wall of the guy holding the beaver. It's crazy.
My God, sounds the size of an alligator.
Yeah. So my mom's name was Diane. So we bought her T-shirts with a beaver saying "Damn Diane," D-A-N.
Nice.
Nice.
When we lived in Boston, those townhouses, the rows, and people were trying to get rid of the rats, and they just could not figure out why they couldn't get rid of the rats, because one of the women, this old lady that lived in kind of the middle one, was feeding them.
Nice.
They were all connected.
Oh my God. They're awful.
Well, I got to admit, I don't have any woodchucks, but I got a dog that gets pretty excited about going to work, and then he gets excited when somebody comes to the door.
You sounded fine.
Well, he's a watchdog, I guess, but he only wanted to play with them. So I'm sure if burglars came, he'd help them to everything, lick their arms as they left. All right. Well, that was certainly a morning of, I didn't expect some of the testimony, but it was helpful to hear. And it's
Now you know why
unfortunate.
I asked you guys to ask the AG the questions, not me.
I understand that, but
Made me sick.
yeah, it's, I understand behavior, but it's something I just don't understand. Anyway, the next witness is James Pepper.
So can I just say, if the noise from the neighborhood gets in the way, just let me know and I'll go back in the room. Okay.
No, we want to keep you outside, Senator.
Well, I would love to, but if it starts interfering, just let me know, because we have 12 kids that live next door.
Well, I started out outside this morning. I thought I could be outside, but people are fixing my chimney and I was afraid there was too much noise, but it's a beautiful morning to be outside. So.
Curtis's barbecue open, Jeanette?
What?
Is Curtis's barbecue open?
I'm not sure if it is. Top of the Hill Grill is, and I'm not sure if Curtis's has opened yet or not. His daughter that runs it now, because he's gotten so old, has been cooking for one of the schools, and they're still delivering meals. So I'm not sure.
Too bad we
I
can't get
can't
the
smell
smell.
it right now. Huh?
We could use the smell through Zoom somehow.
Yeah,
I
I can
can't
hear the
smell it right
birds,
now.
and that's great. Pepper, Deputy
Hi.
State's Attorney, Deputy Executive Director of the State Attorneys Association, James Pepper.
All right, yeah.
Is
so
that a
just,
promotion or a demotion?
uh, I'll leave that up to, personal opinion. So James Pepper, Department of State's Attorneys and Sheriffs. I'm not going to waste too much time with the committee, mostly because these types of crimes are not generally prosecuted by the state's attorneys. They're generally dealt with, referred to the ICAC department, the Attorney General's office, or to the U.S. Attorney's office. That being said, clearly each one of these substantive changes relates to an actual case that was either not able to be prosecuted because of the way the language is written, or had some major barriers to the prosecution. So we are the state's attorneys are very much supportive of this piece of legislation and consider this more of a kind of modernization bill to these crimes. And they should be looked at every couple of years to make sure that they're in line with how people are actually sharing files and using, the internet. And so the state's attorneys are very supportive, and that was our position in the House, and it hasn't changed.
Can you, maybe it's not you, should have asked David Sure. The genesis of this bill, it was a House committee bill that came up kind of late in the session, having a 900 number. Is there a immediate need to, and I had mentioned the effective date, even though it wouldn't be all that far from July 1st, and maybe it doesn't make that big a difference, but is there such an increase right now that this would be helpful?
I think the testimony that I heard and just know about from other detectives that work for the ICAC are just that they are overwhelmed by the amount of cases that are coming in always. And I assume that there's an upward trend now, but I would defer to the, Matt Raymond, if he's still on the line, or to David Scher.
Yep, Matt is there and David Scher is still on. Matt, did you want to comment?
Yep. Yeah, there is a severe increase, and these changes will make differences in the everyday cases. So the sooner the better.
David, did you have it?
I have nothing to add beyond that. I defer to Matt on these issues. Certainly, this is a pressing need, which is why we asked for it originally, and I think the sooner the better for the detectives.
Okay. Michelle, that would be a third amendment possibly to the bill.
Sure.
Thank you. Next is Sarah Robinson. Did you have anything more, Pepper, to add?
No, thank you.
Any questions for Pepper or Matt or David? Sarah, please, thank you for hanging in there and standing by. We kind of jumped around the agenda a little bit this morning. Such is the life of the Zoom.
Thank you for having me. Sarah Robinson, Deputy Director at the Vermont Network Against Domestic and Sexual Violence. And my testimony will also be quite brief. We strongly support these small but important changes that you've been hearing about this morning as proposed in H 936. And as you know, the production and use of child sexual abuse materials has significant and long-lasting impacts on victims. And one thing I just wanted to highlight is that in addition to the abuse that children experience during the creation of such materials, the materials themselves often serve to victimize children and their families really for years, because the abuse lives on in images or videos that are distributed or redistributed. So even after a child is no longer in an abusive environment, the continued redistribution after the abuse really magnifies and extends and can exacerbate the experience of abuse. And as Investigator Raymond also referred to, there can also be an intersection between other forms of family violence, such as domestic violence and child sexual abuse. And we certainly believe that it's important for the law to remain current with technological advances and to respond to the ways that the current statutory framework doesn't fully address the way that child sexual abuse materials are created and distributed. And we're certainly heartened to see the language in the statute modernized to reflect the language of child sexual abuse materials, something within our field that that language has kind of been changed for many years now. So very heartened to see that change in the statute as well. And we would certainly support the bill being effective upon passage. That's really all I have to add.
Right. Questions for Sarah? Comments? Any other comments, questions on this bill? God, we're so efficient. It's only 11:15 and we've swarmed right through the agenda. Was Eric Abbottson here to comment on the bill or any particular?
No, he's the next item. And Stephanie is going to be jumping on in a minute.
Okay,
I asked them to come on early
all right.
because you guys are way ahead.
Well, we'll jump up if Stephanie is not available quite yet.
She should be here any second. I just emailed her and she was on
Oh,
standby.
Great. So if we could shift gears to the e-filing again, the COVID-19 budget issues, and this is Vermont Legal Aid, which I'm assuming would be in the first quarter bill.
Senator Sears,
Yep.
am I going to need to have access to a document for this? If so, I have to move back in.
I don't think so.
Okay.
I think it's pretty, there is a document, but I don't know that you really need it.
Okay, thanks.
It's the legal help that's been needed during the pandemic really is that Vermont Legal Aid has also seen a CARES Act uptick in requests for help. I don't think we have a document, do we, Peggy?
Not that I've received. I haven't received any documents for this.
The first I heard about this was from Cheryl Hooker. Is it Don Bennett? Eric, why don't you come on if you're ready to kind of present, if you don't mind.
Hello, can you hear me?
Yeah.
Okay.
Good morning.
Good morning. Shall I just start? I was also not given clear marching orders, but I do have a few comments.
Well,
and then I'm happy to answer questions.
Yeah, if there's any confusion, it's related to the request in the COVID funding for Vermont Legal Aid.
Yeah, I will definitely address that.
I first got it from Dan Bartlett and Cheryl Hooker. I think it was Dan Bartlett.
I'll definitely address that. So my name is Eric Avildsen. I'm the Executive Director of Vermont Legal Aid. And I want to thank you for the opportunity to address the impact of the pandemic on legal aid and its clients. Like many other organizations, Vermont Legal Aid and our partner, Legal Services Vermont, had to make a rapid transition from our 5 offices to coordinating 90 people working from home. This included reconfiguring both our general legal hotline and the hotline for the Office of Healthcare Advocate to be answered from 18 different locations across the state. We had to deploy computers and monitors to many staff members whose home equipment was not able to support remote work. And in a number of cases, we had to reprioritize our legal work to be responsive to the most pressing legal problems. We made a decision early on to put significant resources into updating our website, vtlawhelp.org, with COVID-related information and resources. That website has garnered national attention as a model for how to respond to the pandemic online. We also prioritized working with the administration and the courts and the legislature to protect our clients' interests where new policies such as an eviction moratorium or utility shutoff ban were needed. And finally, we have begun a series of virtual town halls where we explain the law in critical COVID-related areas, such as unemployment compensation or stimulus checks, and we answer questions live. Those town hall sessions have been recorded and are available on our website. However, as always, the majority of our time and attention has been and continues to be on helping individual Vermonters. We never stopped answering the phone or responding to requests for help online. Our hotlines are now receiving between 50 and 100 calls a day, significantly higher than pre-COVID levels. Views of our website have more than doubled, with as many as 10,000 individual Vermonters visiting at least once a week. While many types of legal cases are on hold, we continue to find ways to help our clients solve problems. And we continue to try cases in the emergency dockets, such as mental health and relief from abuse. As we hopefully begin to plan for our return to our offices and prepare for the surge of legal cases that will accompany the expansion of the judicial dockets, Vermont Legal Aid faces several financial challenges. The first are costs associated, are costs that we have already incurred as we moved to remote work and responded to COVID-related legal problems. We had to purchase about $25,000 in computer hardware and software in order to support staff members working from home. In addition, we had to redeploy staff attorney resources who would have been working on more specialized grants and contracts to respond to immediate COVID-related legal problems. For example, a year ago, we had only 5 calls a week regarding unemployment compensation. Now we can receive 50 a week. Responding to those calls means we are using up our general poverty funding from the state of Vermont and the Vermont Bar Foundation at a much higher rate than usual, and those funds will likely be exhausted shortly, forcing us to either run a deficit or stop responding to those calls and return to work under the funding we do have. We estimate the shift has cost us already between $50,000 and $100,000. Looking forward to the new state fiscal year, we see a need to expand our services in 4 areas: housing, family law, unemployment compensation, and debt collection. Back in January, the state's Access to Justice Coalition proposed a major funding initiative aimed at addressing several critical unmet legal needs. While that effort will need to wait for another year, several of the elements can be adapted to provide a timely response to the coming surge of COVID-related legal cases. The coalition includes Vermont Legal Aid, Legal Services Vermont, the Clinic at Vermont Law School, the Vermont Bar Association's Lo Bono Project, the Bar Foundation, and the Supreme Court. We had already designed a family court clinic program that could be adapted to focus on the large influx of family cases we expect once the courts resume a more regular schedule. We anticipate that the most pressing issue there will be the resolution of custody disputes. The stay-at-home order has had the effect of throwing a great many existing shared custody and visitation orders into confusion, exacerbating existing issues and creating new disputes. In addition, there continues to be no funding to provide representation in involuntary guardianships, despite the statutory mandate to provide counsel in those cases. The coalition has already requested an additional $150,000 in the initial state fiscal year 21 budget for this and other work. However, the largest area of concern is clearly housing, ensuring those with apartments and home can remain housed, preventing those temporarily housed from becoming homeless as motel supports are withdrawn, and helping those who are homeless get rehoused as quickly as possible. This is work Vermont Legal Aid has always done, and we believe we could have a profound impact on the successive efforts to prevent homelessness in the middle of a pandemic. Last week, after discussions with nonprofit housing providers and the Landlords Association, we developed a proposal to couple an expanded state of Vermont back rent program with access to legal aid lawyers in every county in the state. Vermont has long had a back rent program, which provides cash to cover rent owed by tenants who are eligible for that program. We propose expanding this program beyond back rent to a more comprehensive rent arrears program. Our new program is designed based on the experience we have had in several pilot rent escrow programs in several counties over the past few years. Most recently, in Franklin County, we have been very successful in preventing homelessness due to a grant which allowed us to represent any tenant at the rent escrow phase of an eviction. The court provides us the names of the litigants ahead of time so that we may contact the tenants and let them know we are available to represent them. In a large majority of these cases, we are able to advise the tenant and negotiate with the landlord to preserve the tenancy. Where that's not possible, we have been able to negotiate an orderly exit from the tenancy, which has allowed the tenant to find alternative housing without becoming homeless first. Building on that experience, we have tailored a new program to respond to the particular circumstances of the pandemic. With the number of unemployed Vermonters hovering around 25%, and the large number of eviction cases already queued up in the court system, we believe there needs to be an aggressive response to avoid a further crisis in homelessness. We have proposed that the state set aside $50 million in CARES Act funding in a housing stabilization fund to provide for up to 6 months of back rent or rental payments. Coupled with this fund would be access to legal aid lawyers, not just at the rent escrow hearing, but at any time during a tenancy. We have learned that the best intervention is actually far upstream from the eviction trial itself. If we can contact landlords before they have to file an eviction, we have a much greater chance of saving the tenancy. So the proposed program would allow us to represent tenants at any phase of their tenancy, and also if they are homeless or seeking housing.
As far as the 50 million in the CARES Act funding, I suspect that's would be part of the governor's relief plan. That would be more an economic development committee than this committee. We were
I believe
looking
there was
more-
already testimony there.
Yeah, and
I
I
would just-
believe that, I think this committee's looking more at legal representation and for people in the system, so.
Right.
But
I just
no,
want to
no,
emphasize
it's fine
that
yeah,
that our lawyers in the proposal to make available between now and December 31st, we're proposing that we deploy the equivalent of 7 full-time equivalent lawyers, whether from Legal Aid or Legal Services Vermont or the La Bona Project, to be available to represent tenants at any phase in their tenancy where there's a problem. And I was only talking about the CARES Act funding for rent stabilization is to be able to access that funds. It makes the legal aid lawyer negotiating the case much more effective.
Yep.
Because they are able to put together that access to that fund with the tenant who needs it, and to ensure that landlords who get that fund, money from that fund, don't turn around and evict the tenant the following month. And so our proposal is to use a combination of legal aid and other providers to provide representation in every county in the state in any eviction, but also to respond to requests from tenants or landlords for cases not yet filed in court.
Actually, and no, that's fine. I just wanted to make a distinction between what this committee might recommend to the Senate Appropriations Committee versus what economic development might. And that's all I was trying to do, Eric.
Okay.
All right, one other, I guess the question is, if the money was provided to hire these attorneys, could you find the attorneys? In talking with the state's attorneys and the Defender General, they're having a hard time finding attorneys.
Well, my sense is that, or as we've talked about it internally, we expect initially, if we got funding, we would redeploy some existing legal aid lawyers in the first instance, just to get off the ground running. We regularly get contacted by young lawyers looking for work. I have a list of people who have been looking for work, and I've been telling I don't have any funding to provide work for you. Obviously, we'd have to have people who are currently admitted in Vermont, and it would provide probably some challenges. But I don't actually think of that as a problem. We have a program with the Vermont Bar Association where some lawyers have agreed to take cases at a reduced fee, and we already operate that panel, and the person who runs that panel has indicated that they could expand the panel, that there are lawyers who are available to expand work. So I think we could meet this demand.
Okay.
At least that's my belief currently, is that there's a bunch of lawyers who are looking for work out there, and maybe they're not experienced enough for the state's attorney, but there's certainly people we could work with.
Okay. Do you have a document you could share with Peggy so we could talk about this tomorrow, perhaps, is the exact request?
Yeah, well, it's being created as we speak. So yes, as soon as we get it created, the proposal was just developed last Friday, and so Thursday actually, and so it's still needing to be edited a little bit more. But I will get it to the committee as soon as possible.
Okay, Stephanie, are there questions for Eric? Thanks, Eric. Stephanie, did you have some comments on this?
I don't really have comments. I do know that there was one document from Legal Aid regarding the eviction piece, and
That has been sent to Senator Kitchell, and we have that in our list of things, of requests. It wasn't addressed in the budget adjustment, but it's on the list. And the thinking was that it would probably go, if there's a housing package, the eviction piece would be part of that for legal aid. That's what I understand.
Yeah, Wendy Morgan or Jean Murray may have already shared that document, and it hasn't made its way back to me. So that could well be true, and I will double check with them when I get off here and
But
make sure
it
you
would
have.
be
what you need.
helpful to get that other document to Stephanie and Peggy Delaney for this committee to consider the other requests, so we can decide what we want to recommend to the Senate Appropriations Committee.
Absolutely. I'll try and get that by the
If
end.
tomorrow isn't, if it's not available by tomorrow, then we'll take a look at it next week.
I will get it to you. Happy to do that.
Any other questions for Eric or Stephanie on this? I was just trying to set up so that people are aware of what's coming down the road. Senator White had a question. Oh, no, she was just holding her pen up. I hate Zoom, quite frankly. It's very difficult. I mean, it's much better than on the phone without looking at people, but I miss the committee room and talking in person with people. So just as a comment. Anything else? I don't want to hold people. I know you've all got a lot to do between now and 1 o'clock when the Senate meets again. Senator White's committee, it'll be voting out 3 or 4 more bills today.